Let's talk about something that most people never anticipate: accidentally disinheriting someone you care about. Sounds bizarre, right? But it's a real issue that happens when proper planning does not take place. Accidental disinheritance can happen for a variety of reasons, like forgetting to update your beneficiary forms, failing to account for remarriage or blended family dynamics, or incorrectly thinking that a will cover everything. The first story we'll talk about is called Pension Pickle, and it was covered in the New York Post. So, Bruce and Anne were married for over 20 years. They married a little bit later in life. Anne had stayed at the same job her entire career. When she passed unexpectedly, her husband anticipated that he would be receiving all of the retirement funds. But here's the thing: Anne had never updated her beneficiary forms. So like I said, Anne had been at that job her entire career. When she started that job, she was single, and she made her sister the beneficiary. Now, she went on and she married Bruce. She never updated her beneficiary form. So when she passed, her sister was named as the sole beneficiary. She accidentally disinherited her spouse. The next question I usually get is, well, what about the will? If the will states that Bruce gets all of the money, doesn't that solve our problem? The answer is no. A beneficiary form will always override a will. So even if the will stated that Bruce should be the beneficiary, it doesn't matter. Anne's sister received all of the money. Let's take a look at another case study. We'll call them the Smith family. Mr. Smith passed away and he left a large company 401k. Mr. Smith had 3 adult children from his first marriage. Following a divorce, he remarried. Now, after his death, the 3 children came forward and said it was their father's wishes that they inherit the 401k. But here's the problem: there was no beneficiary form on file. The plan rules stated that the surviving spouse would receive the assets. So that's what happened. Mr. Smith's wife received all of the assets, and the outcome was the accidental disinheriting of the 3 children. Again, some people say, wouldn't a will have solved this problem? No, not in the case of a 401k, because they have to follow the plan rules. The next thing I hear frequently is, can't the kids fight the ruling in court? Yeah, they absolutely can. They can spend the time and the money and take their stepmom to court. The problem here is they will most likely lose because they're going to fall back on the plan rules. Since this was a 401k, the rules stated in the plan, since there was no beneficiary, is what is going to be upheld. Don't make the mistake of accidentally disinheriting someone you love. Following a marriage, a divorce, a birth, or a death, make sure you revisit those forms and that they reflect your wishes.